Well, it's 12:30. Good afternoon, everybody. Thank you for attending our webinar today, which is entitled Sanctions, Your Questions Answered. And really, we're hoping today to provide a really sort of practical overview of our approaches to some of the most frequently encountered questions that we've had from clients in relation to sanctions generally, and also in particular in relation to the sanctions that have recently been enacted in response to the invasion of Ukraine by Russia. I think it's been a steep learning curve for all of us, and so we're really keen to have this interaction with you. Can I have the next slide, please? So just sort of a really brief overview of the structure of today. The talk's going to be divided into two parts. My part one, I'm going to talk a bit about sanctions compliance, the risks, the rules that tend to apply, how you can approach those rules, navigate them, hopefully keep deals on track or minimize disruption to what you're hoping to achieve. Catherine is going to talk specifically about the impact of sanctions rules on contracts, and how questions such as when can you walk away from a contract, what are the things you should be doing and not doing in terms of just managing the contractual process and minimizing risk, and also the sorts of provisions you should be thinking about including in contracts moving forward. Next slide, please. So the context, I mean, I think a question that lots of people have been forced to grapple with over the last couple of months is, well, what are sanctions? Why are they relevant to us? Why do we have them? And quite obviously, sanctions are a non-military weapon of choice when a government wishes to signal its disapproval of the behavior of another state, another regime. We've obviously been focused on Russia and the Russia sanctions rules that have recently come in, but they are, of course, not the only sanctions program. We've seen rules enacted to deal with problems in Iran, in North Korea, in Cuba, and companies have frequently found themselves caught up in this, found their deals derailed, etc. So what we'll mainly talk about today will relate to Russia, but I think a lot of what we'll discuss is applicable also to other sanctions regimes. And I think although Russia is the focus now, I think that a lot of what we'll talk about today, particularly in Catherine's part, will be about future-proofing your deals so that if sanctions problems arise in jurisdictions where you have your activities, that you're not taken by surprise and that you are better prepared. One of the things that we've really seen over the last few decades is a sort of unilateralism with regard to enacting economic sanctions regimes. So that means that rather than sort of having a lot of sanctions issued from the top, the UN, you see different states going it alone, enacting their own sanctions rules on companies that fall within their jurisdictions, trade blocs in the case of the EU. And this often causes a headache for companies who find themselves having to deal with sometimes conflicting rules and think about all of the jurisdictions that might bite on what they're trying to achieve. What we'll talk about today largely will relate to the USA, the EU, and the UK, the three most frequently encountered regimes that we come into contact with. But it's not to discount the fact that you may come up against other regimes, such as those of Switzerland, Canada, India, to name just three. As I say, this growth of unilateralism with regard to enacting sanctions programs really causes a headache for companies and a challenge. There is a common denominator, though, with modern sanctions regimes. What you commonly find wherever the jurisdiction is that the authorities give themselves a power to designate certain entities or natural persons with certain restrictions and prohibitions, so that those entities are not able, for example, to deal with their assets. They're not able to access their assets in some cases, or their funds, and they're not able easily to access goods and services provided from the countries where the sanctions regime is in force. Usually what you'll find as well are designation criteria within sanctions rules. Those basically sort of set the boundaries in terms of the type of individual that could be targeted with restrictive measures, of the type of organization that could be targeted. So with regards to the Russia regulations, the designation criteria will include sort of connection to the Putin regime, a direct involvement in the wrongful behavior or perceived wrongful behavior, and also consideration of whether or not an entity or a person is linked to a sector of strategic national importance, linked to the regime in question. The first question I wanted to just sort of deal with is, how do I know if a party is sanctioned? Because that's the first concern. We've had with clients, for example, concerns where they've been dealing with projects in Russia. Their first question is, well, is this someone I can continue to deal with? And there are a number of free resources where you might want to start. I've listed 3 there. These are search engine tools that are free of charge. There are better professional resources there available, which will provide you with more detailed information about sanctions measures, and will maybe give you more information in relation to some of the other jurisdictions not listed there. But these are nonetheless an excellent resource. Next slide, please. And also, I think just when you're using those search engines, a recommendation that I would have would be to ensure that what is called the fuzzy search facility is turned on. And fuzzy search basically means that the hits that you get will include names that are perhaps not exactly the same as the one you've put in, but also quite similar. And that's quite useful with Russian names because, of course, they get transliterated into the Latin alphabet, and different people sort of transliterate in different ways. Some people will use a Y, some people will use an I. So it's good to have that facility because you're more likely to get a relevant hit than if you don't use it. I think one of the key points, though, is to bear in mind that the direct hits might not be the extent of individuals or organizations that are caught by sanctions regimes. What do I mean by that? Well, the sanctions rules will commonly not only apply to the directly designated individuals or entities, but also organizations connected to them under their ownership or control. So, for example, Regulation 7 of the Russia Sanctions EU regulations provides that that connected persons under the ownership or control of designated entities will also be subject to sanctions restrictions. And these might be organizations which are not actually listed in the hits that you see when you do your searches. So this really puts an onus on you to do your due diligence and to get as much information as possible about the persons that you're dealing with or the persons involved in the project. For the purpose of Regulation 7, ownership usually is constituted by a person having more than 50% of voting share rights in a company, or the right to appoint more than half the board. But those are just 2 examples, and Regulation 7 lists other types of criteria that qualify for ownership or control. There are similar kind of rules about connected persons in the US or EU. Those need to be checked as well, because these things are not always identical. The provisions are not always identical across jurisdictions, so you do need to engage with the detail of those and consider whether a person could be considered connected. Keep an audit trail of the searches that you do. That might come in really handy if ever a problem arises, to at least show that you did make efforts to ensure that you were not breaching the rules. And keep your results under review. We've seen things move quite quickly. We've seen parties who begin as not sanctioned then fall under the sanctions list, and problems arise at that stage. So, for example, if you're in the course of negotiating a deal, it might be a good idea to do a search on the parties that you're dealing with at the beginning of the negotiation process, in the middle of the negotiation process, pre-signing, and possibly even at key stages of contract performance. But just sort of bear in mind, these things are not set in stone, and it is good to keep your searches under review Sometimes also names can be removed and not just added. So sometimes it could be good news, not bad news. So just moving on, sort of what I want to do here is just talk about some of the key features of the three jurisdictions we want to discuss today, and also to talk about when they may affect you. So starting with the UK, the key kind of parent legislation is the Sanctions and Money Laundering Act of 2018, which sort of sets the boundaries for what government can do with regard to sanctions legislation. And this basically, these rules have come in to deal with the post-Brexit situation. Previously, it was all set at EU level, but things have moved on, and obviously post-Brexit, the UK has gained a lot of autonomy in this area, so they're very keen to have an active sanctions regime, and SAMLA is really the key piece of legislation that contains some of the key definitions, etc., which flow into other rules. The Russia sanctions EU exit regulations of 2019, they are the key Russia-specific set of rules. They basically started off, inverted commas, replicating the EU rules or carrying the main features across. But one of the key features of the Russia sanctions EU exit regulations is it allows the Secretary of State to designate persons connected to the regime or which fulfill the designated criteria, allows them to designate those persons and organizations quite quickly, and really give a lot of power to the Secretary of State. That's not the sum total of what's included in there, but I think one of the key features. The Office of Financial Sanctions Implementation, or OFSI, is the body that is basically charged with administering the rules. Very important with regard to setting guidelines and also the licensing regime that we'll talk about. And when do the rules apply? Well, they will apply to businesses that are active on UK territory, to UK citizens, or UK incorporated companies or bodies corporate, or individuals who are carrying out their business in the UK. The penalties for breaching sanctions regulations, for example, dealing with somebody who you're not allowed to deal with, or breaking an asset freeze, etc. Well, the penalties are quite severe. For individuals, there's a potential for prosecution and custodial sentences of up to 7 years. OFSI has a power to impose sanctions directly, and those sanctions can be the greater of up to £1 million or 50% of the underlying transaction value or the underlying assets that are being provided to the sanctioned entity or moved around, dealt with, etc. As I mentioned there, Standard Chartered Bank was fined £20.5 million for making loans available to persons on the designated sanctions list. So there is a real threat here of sanctions being imposed, penalties being imposed. Next slide, please. So just sort of moving to the US, the US rules, which I haven't listed there because there's so many different sets of rules, but those are administered by the Office of Financial Assets Control, which is a division of the US Treasury Department. They apply primarily to US persons, US citizens or permanent residents, subsidiaries of US parents, including overseas subsidiaries of US parents, and persons physically in the USA. So those are who the rules are primarily addressed to. So if you're a UK subsidiary of a US company, you will be really concerned about US rules. And again, as with the UK rules, we see the ability for some stiff penalties to be imposed. Those can be, in terms of civil penalties, up to $250,000 or twice the value of the relevant transaction. Criminal penalties can include fines of up to $1 million or imprisonment up to 20 years. Something that also, I think, frightens a lot of companies is the potential for the US authorities to add companies in breach of the rules to what's called the SDN list, Special Designated National List, which basically is a bit of a blacklist of companies who US companies should avoid dealing with. Now, the potential of being added to that list is quite severe. The US is quite aggressive in terms of pushing its rules overseas. And also, the bar can be quite low in terms of when you, even as a non-US person, can be considered to fall within the US jurisdiction. So I think for one of the key takeaways for today is, don't assume automatically that just because you're not based in the US or your deal doesn't involve the US rules might not apply. The example of how they could and catch you out could be where payments are made in US dollars. If that's the case, then the likelihood is that your transaction will need clearance in the US, and that will bring you within the scope of the US rules. And you could be accused of causing US banks to breach their own sanctions obligations, which is something you really want to avoid. The US can also impose what are called secondary sanctions against non-US persons with no link to the USA, where it's concerned that those persons are basically not taking account of the US rules. Now, that won't normally lead to the imposition of fines if there's no direct jurisdictional nexus, but it could lead to an exclusion from the US market and US banking system. And as I mentioned, could restrict your ability to deal in dollars, which could really have an effect on you. So, as I say, it's important to take the US rules into account. Turning to the EU, things are a bit different here because the EU, although the European Commission and the European institutions will set the rules and the designations at an EU level, it is the member states which are responsible for imposing penalties, having rules about the imposition of penalties, etc., and also for administering what's called the licensing regime, which I will come on to. The EU rules apply to all EU nationals, including entities incorporated or constituted under one of the laws of an EU member state, regardless of where they're doing business and whether that's inside or outside of the EU. But the EU does not favour pushing its sanctions rules to companies having an extraterritorial effect. Now, if your business is inside of the EU, then you do need to be concerned about the potential for the EU rules. But it's not like the US where they impose secondary sanctions on companies who are not taking account of the EU rules, and the penalties are set at a national level. The EU actually, an example of where you can get conflicts between different jurisdictions, the EU actually prohibits prohibits EU companies from complying with certain US sanctions programs which it disagrees with. A good example of this is Iran, where under the Trump administration, the administration of the day there took a very dim view of the deal that had been done by the Obama administration with Iran, and the US sought to distance itself from that deal and to punish companies doing business in Iran, and included that went as far as imposing secondary sanctions on some non-US persons. The EU actually said it would be a criminal offence for companies to comply with some of those rules, which it regarded as illegal, and took a very dim view on the extraterritorial application. So that led some companies to be in an awkward situation where they were damned if they did and damned if they didn't. They didn't know whether to comply with the EU rules or the US ones and could face penalties either way. So this is a good example of how sanctions rules can conflict from different jurisdictions. Next slide, please. Just want to take a moment to go through the different types of sanctions that apply. You do your search on a person. It's important, if they're a sanctioned person, it's important to pay attention to the actual specific measures that have been applied against them, because that will set out what you are allowed and not allowed to do with that particular person. The main tool of choice with regard to sanctions tends to be imposing asset freezes, and this is common to the EU rules, the UK rules, and the US rules. We'll talk a bit about the UK rules, though. The scope of what is meant by an asset freeze is found mainly in Regulation 11 of the Russia Sanctions EU Exit Regulations 2019, at least for UK purposes. And this basically says that you should not be dealing with funds belonging to a person that has been subject to an asset freeze. Dealing with funds includes using those funds, altering the state of those funds, for example, turning cash into shares or allowing access to them. So if you're a bank or if you operate an escrow account, you should not be allowing the designated person access to the funds that they own, that they need to be cut off from those. You also shouldn't be allowing yourself to accept payment of those funds. So by doing that, you're facilitating a breach. And you're not allowed to engage in measures that are basically, although on the face of it, not in breach of the rules, that basically circumvent the main prohibition. We'll talk a bit more about that later on in the case of, we'll talk about the case of Afrasiabi where that came up. It's important to pay attention to the language here that it talks about funds and economic resources, and those are not the same. I mean, funds basically includes things, obviously sort of cash, it includes letters of credit, it includes checks, it includes basically direct monetary resources. Economic resources goes wider than that, includes goods, includes tangible or intangible goods, which could be used for exchanging, for getting goods and services. So sometimes people tend to think of economic resources as being personal chattels like yachts or cars, but it might actually go further than that, obviously include things maybe like shares as an intangible good, potentially other assets as well. So it's better to take a cautious approach to what an economic asset could include. And this is relevant really when you're thinking about providing goods or services to a sanctioned individual or an individual at risk of coming under the sanctions regime, because the Russia regulations generally prohibit the provision of economic resources to persons who are subject to an asset freeze. Other types of sanctions include bans on financial services. So this has meant that some banks are no longer able to have UK clearing services in the UK. And this can become a problem for companies because they may not be banks themselves, but it can be a headache if they're dealing with an entity that would usually use a bank that has now been subject to these types of sanctions. And then the question arises, well, how then are we going to get paid? What route are we going to use? Some banks that are subject to this, for example, include Sberbank, VTB Capital, big Russian banks that are now their sanctions began with just a ban on financial services, which was already a major headache. It even went so far as to prohibit wire transfers being made to the UK. There's also a ban on the provision of new debt, which I think in many of the people attending won't affect them so much, but that includes things like not dealing in letters of credit or providing, in some circumstances, just providing loans or potentially even credit arrangements. Again, that needs to be thought about if you're sort of operating a kind of a deferral on payments arrangements. You need to think about whether that could potentially fall within Regulation 17 if that's relevant to the person you're dealing with. There are also restrictions, obviously, on the ability to make military technology or dual-use goods available. And the details of the regulation in those circumstances really needs to be thought about. But if you're in the construction or engineering sector, I think you do need to think about, if you're involved in development projects, you really do need to be doing some due diligence, really making sure that there's no aspect of what you're doing that could be connected to military technology or dual-use goods, and you need to be thinking about the materials you might be sending over to a target jurisdiction that are perhaps required for the purpose of progressing the development. Energy technology is restricted as well. The provision of energy technology is restricted by those regulations mentioned there. And also there are restrictions on movement of aircraft. So Russian planes, as many of you be aware, are prohibited from overflight in the UK. And these sorts of transport-related restrictions can become relevant to the practical aspects of your deal. So, for example, if you're thinking about shipping goods and materials over, you need to be thinking about the routes that those goods and those shipments will be taking, and whether that is going to be permitted or whether it's going to cause you a problem. Next slide, please. So one of the first questions that we get asked a lot is, can we get paid by our Russian clients? And often people will be caught, they've signed a contract, they're supposed to be providing goods or services, they're involved in works for a contract that they've carried out the services already. Can we still get paid? And the answer really is, it depends on the types of restrictions that are enforced, if any, against your counterparty. There is not a general ban on trading with Russians. It really is detail specific, and with smart sanctions these days, or smart sanctions they're called, there's really a more targeted approach, and you need to engage with the detail. But obviously a very good idea is to check whether the paying party is a designated person. And if it's a corporate entity, you need to go beyond that and also ask, well, what about their directors and shareholders? Are they under the control of someone who is a designated person? And really to go all the way up in terms of corporate entities to really try and get to the top, the ultimate ownership and control, and really look at that. You need to ask questions, as I've said, about the bank that they're proposing to use, if they are the paying party, and consider, is that bank subject to sanctions? Could there be a problem? Do we need to alter the way in which payment is going to take effect? With regard to banking as well, thinking about where the transaction will be cleared, what jurisdictions is the payment going to cross, what banks will need to be involved, what are the rules on sanctions in those jurisdictions. If any of this is problematic, then you should consider seeking a specific license from the jurisdiction where the problem has arisen, and we'll talk more about licensing. Specifically with regard to the construction sector in the UK, though, a common position that we've found is that the contractor with whom our client has perhaps got a contract is not on the sanctions list, but the ultimate beneficiary of the project, the ultimate client, is on the sanctions list. So that presents quite an interesting situation, because there is an argument that, well, if the arrangement is pay when paid, so if you're being paid by a contractor who's not on the sanctions list, but ultimately they're waiting for money from somebody who is on the sanctions list, there might be an argument about whether or not that's basically indirectly making the money available, and therefore is that circumvention and something you need to be concerned about. But on the other hand, it's also worth looking at, in the case of the UK and the Russia regulations, Regulation 58 of the Russia regulations appears to give a potential out for situations where a third party, which is not subject to sanctions, is paying from its own resources, and those are not under joint control with a sanctioned person. And there isn't any case law on that yet, but it's something that we've picked up as potentially useful. But I would urge caution with all of this, and these situations need to be carefully thought through. But there might be routes to getting paid, even in situations where there is ultimately a problem. Quite often that will involve licensing and some engagement with the authorities as a measure of safety. So the flip side to payment is, can we still supply goods or services to a designated person? And here we go back to what I mentioned before about economic resources. For certain persons subject to certain sanctions, in particular asset freezers, Regs 14 and 15 prohibit the provision of economic resources to those persons, specifically in circumstances where the resource itself could be traded for goods or services, or where the provision of those economic resources could provide a significant financial advantage to the target person. So there isn't a blanket ban on just providing any sorts of goods or services, but you do need to exercise caution, and you do need to wonder about whether or not you could fall within Regs 14 or 15, and that's something on which advice should be taken. As I mentioned before, some goods may be outright prohibited, and that could include military and dual-use goods. So special consideration around those, and you really need to take advice on those situations. as I said, in terms of all this, it's important to consider the meaning of economic resources and the meaning of making economic resources available. What is making available? But the case law to date has tended to take quite a broad construction of those terms. So in the Afro-CRB case, which I'll mention, making available included goods in an intermediary state, even if they weren't immediately ready for use. So caution pays with some of these situations. Next slide, please. So the next question we get asked when we realize that there is a problem tends to be, well, could we just restructure the deal? Could we just substitute the company that we are dealing with, so we're not dealing with a designated person and we can keep the show on the road, or deal with another company or another jurisdiction where there isn't a sanctions problem? And that is a natural first question. Unfortunately, it tends to be fraught with risk. Regulation 19 of the Russia regulations is one example of a common anti-circumvention provision that you will find in sanctions rules. And basically this says that not only must you comply with the direct rules, but you mustn't do something which basically is aimed at frustrating the aim of the prohibition which is in place, or enabling the facilitation of a contravention of such a prohibition. So the language there is quite wide, and it includes measures the object or effect of which has the result of circumventing that prohibition. So again, there's a real broadness to this. Next slide, please. To sort of give an idea of how it works in practice, I thought it might be useful to mention the leading case on this, which is Afro-CRB. Now, Afro-CRB involved a case in Germany with the EU rules. What was happening there was that a German company had been approached by a company in Iran to provide technology that was commonly used in making nuclear weapons. And obviously the Iran sanctions aimed to prevent nuclear proliferation in Iran, which was a real threat to regional and international security. And there was evidence that the German company knew that ultimately, although the party that was going to be buying this stuff wasn't itself on the sanctions list, but ultimately they were going to be using that technology for the benefit of an Iranian government organization that was engaged in the production of dangerous nuclear weapons. So the German company made an application for an export license to sell those products to Iran, and at first blush, the German export authority didn't see a problem and told the German company, well, look, this is fine, you don't need a license actually, because the party you're dealing with is not on the sanctions list. At a later stage, however, the German export authorities did get wise to the fact that there was a connection between the entity to which the goods were being sold and the Iranian government, and started asking some more questions about this deal. And it transpired that actually the individual involved had known all along that that although the party it was directly dealing with wasn't on the sanctions list, that it would be making the goods available to a party that was on the sanctions list. And not only that, but this basically ran clearly directly contrary to the policy of the Iran sanctions, which is to discourage nuclear proliferation. Here was this technology being shipped to Iran and would have exactly that purpose. So the court, the German court, which referred a number of questions to the European Court of Justice, was left in no doubt that this was very much the sort of thing that the anti-circumvention provisions had in mind. And the court took a very broad view of what was meant in the legislation by making available goods. Could include intermediate goods, it didn't have to be the final goods. And also, when an individual would be considered to be knowingly engaging in circumvention practices. So I think that the moral of this story is really one of exercising caution around restructuring deals just to kind of get out of the problem. Bank SEPA, which I won't deal with in any detail, one thing that was an EU case as well, which basically approved AFRA-CRB, and the court, on my reading of the judgment, appeared to go a step further and actually said, well, faced with a circumvention question, the burden of proof will actually be on the individual that's allegedly tried to circumvent the prohibition. It will really be for them to explain themselves as to why that wasn't the case. I think from our reading of the case law, I think there are 4 relevant questions that companies need to be asking themselves about restructuring. I think, ask yourself, is there a legitimate commercial purpose for the new structure that you're now proposing other than avoiding sanctions? So, for example, is there a legitimate commercial purpose to you using a shelf company in Panama to make shipments? Does Panama have any particular relevance to this jurisdiction, or is it just that actually Panama is quite a discrete jurisdiction where people keep themselves to themselves and information isn't readily available, and it might be, I don't know, it might be quite lax on sanctions rules itself. If basically the answer to that is no, there isn't really a legitimate commercial purpose, then I think you potentially do have a problem. I think just ask yourself, is the result of the restructuring the frustration of the sanctions policy? AFRA-CRB, obviously it was, because we were looking to try to reduce nuclear proliferation in that country, and what the exporters were doing ran completely contrary to that, given the technology. Ask yourself, will the project as restructured still benefit the designated entity? So, for example, the contractor you're dealing with might not be on the sanctions list, but if ultimately the client is, then clearly the ultimate client is still benefiting from the deal, and there could be an issue about circumvention. And also, I think, look at the degree to which the project has been restructured once the relevant sanctions have come into effect. Because I think for any prosecutor looking at it, they will be asking themselves, well, this is a bit of a coincidence that all of a sudden it was once those sanctions came into effect that it was at that point you looked to restructure the deal. In contrast, where you have a multi-tiered project or supply chain arrangement that has always been that way from day one, so you have a contractor and a subcontractor, for example, then there is more likely to be a defense that, look, this wasn't circumvention, this was a legitimate commercial structure. But that is just one factor to be taken into account along with others. Next slide, please. So something else I want to talk about today, which is of relevance to a lot of our clients: can we obtain a license to carry out an activity that would otherwise be prohibited? And the answer to that is potentially yes, although bear in mind that there is no obligation on a licensing authority to license your activity, and it will look quite closely at the circumstances. Before we talk about specific licenses where you are outlining your particular circumstances to the licensing authority and trying to get a bespoke permission to do your particular deal, consider whether a general license might be available. And general licenses, basically, they will exempt blocks of categories of transaction with named entities, named types of transaction for a designated period. And really, the aim of general licenses is to relieve some of the draconian effects of sanctions for businesses that happen to just be finding themselves dealing with a sanctioned entity. The idea is to give them some breathing space, usually to kind of wind down transactions so that they're not looking at the sorts of dire contractual problems that Catherine will talk about in her part of the talk. So one example was a general license with regard to dealing with Sberbank, a big Russian bank, which affected quite a few clients, I think, in the construction sector. If you can fall within one of the general licenses, it saves a lot of paperwork and means that you can benefit from that general license straight away and not wait for an authority to pore over the details of your deal and decide whether or not to give you the license. But do consider whether it will cover all aspects of your transaction. So, for example, is there another designated entity involved some way, and might you need a permission for that? Consider whether there are other jurisdictions, because the US will not be impressed if you're breaching their rules just the fact that you're within the scope of an OFSI general license, they will expect you to square your position with the US sanctions rules as well, if those are applicable to your transaction. Within the general license as well, there may be specific notification requirements. You may need to tell the authorities that you're relying on the general license, give them information about that particular transaction, even if you are properly within it and you're not seeking their consent. And also bear in mind the expiry on the general license, and ask yourself if that's going to give you enough time to complete whatever it is that you need to do. Next slide, please. For most businesses, though, they won't have a general license, and they will find themselves in the category of seeking a specific license, which is, as I mentioned, in the case of the UK at least, OFSI looking at the detail of a particular transaction and considering whether or not to give you a specific exemption to allow you to carry that out. There's quite a detailed application form to fill in when applying to OFSI. And one of the key bits is to identify which of the grounds of exemption you're relying on when you're making your application. There is a limited list set out in Schedule 5 of the Russia regulations. And I think for businesses in commercial situations, the most relevant are one of the grounds, which is satisfaction of an obligation of a designated person. You are seeking to allow, you are seeking to get permission to allow the designated person to do whatever they've committed previously to doing, usually under a contract. That's quite a handy ground of exemption. But it is quite restrictive, and they will usually expect, for example, that your obligation was already in effect at the time when the sanctions measures were initiated, so that it's really a prior obligation and not a new one. There is a catch-all ground called extraordinary situation, which is getting used quite a lot because of the restrictiveness of other grounds. So that is quite a useful one to rely on as well. Even though strictly the guidance says that it's not there as a catch-all, everybody is using it as a catch-all when the other grounds just don't work. When you're submitting your application form, it's important to be as complete and specific as possible, and also to consider all aspects of the transaction where you might need specific guidance. So, for example, it's not just a question of getting permission for payment if providing the services or goods under the contract could also breach the sanctions rules. And we recommend having a really good cover letter, because I think the way that the application form is structured isn't particularly helpful for just the authority to get a good general feel of what it is you're doing. So a good cover letter can help, really just sort of help outline the background and help them to understand. Next slide, please. As I mentioned before, it's important to consider other jurisdictions where you might need a license. To consider when you're doing that, things like if you're shipping materials, the ports of call, and whether the route of your shipment could bring in other requirements for other licenses, clearing banks, etc. Those sorts of considerations should be taken into account. Just in terms of managing the application process, I think it's important to try and keep on top of OFSI while also being sympathetic to the fact they're under a certain degree of pressure right now with volumes of applications. Their target time is 4 weeks, but you might find it goes on a little longer than that. So I think try and build that into your contractual relationship, which is something that Catherine will talk about in part 2. If OFSI proposes a license, consider whether the scope will cover all aspects of your deal. And quite often they will have attached terms and conditions to the license. It's important those are complied with. Failure to comply with those terms and conditions is a criminal offence. Think about who in your supply chain needs to be aware of those terms and conditions and ensure compliance at all levels of the project. Next slide, please. I will just mention here that there are these separate licensing processes in the US and the EU. The US, it's very much centralized through OFAC, whereas in the EU, licensing is at a member state level, but engage early with those bodies if you do need permission in those jurisdictions. Next slide, please. And another consideration to take into account, which has been a headache for many of our clients, is whether sanctions affect insurance coverage. And quite often they do, and quite often what you'll see in coverage arrangements is an exclusion clause, which basically allows the insurer to cease provision of cover where that would fall foul of sanctions regulations. I think it's also probably fair to say there is a general nervousness anyway about the provision of insurance for new projects that fall within certain problematic jurisdictions, regardless of whether or not the insured is a designated person. But of course, you've got to have a fair degree of sympathy for insurers, because they themselves have found themselves on the wrong end of enforcement actions because they've been making payments to, or forced to make payments to designated persons under insurance coverage. And there've been a number of cases, for example, in the States where penalties have been imposed. They can't do that. In the UK case I've mentioned there, the court did uphold the legality of an exclusion clause that had been put in place in an insurance contract, but the court did stress the importance of looking at the construction of the clause and considering whether it was applicable to the situation at hand. I'll also just mention under the general heading of insurance that Russian companies in aviation and space are prevented from access to the UK insurance sector. That is obviously a very niche area, but I think this is something that you could see a further development of as time goes by, with maybe other sectors of national importance, strategic importance, being barred from the UK insurance sector. So another question then really, well, as a company, what are the key action points for me to sanctions compliance? And I think the obvious starting point is to have a good sanctions policy in place, which means having in place good company routines and processes, building into your commercial processes the need for searches at the pre-negotiation stage, mid-negotiation, pre-closing, as suggested points where you might want to do that. By no means prescriptive. You might want to include additional gateways. I would encourage investing in good software, a good software package to conduct power searches and to do things like deliver information on ultimate owners, ultimate beneficial owners. Ensure your staff are aware, ensure the relevant staff are aware of the importance of sanctions and sanctions compliance and what they need to do. That includes the commercial side, the salespeople, because they might well think they've just hooked a really valuable client and not unwillingly committed the company to providing services to someone on the sanctions list. Accounts as well. I think anyone involved in payments needs to be aware of the requirements for banks and ensure that they are not seen to be sort of putting banks in breach of their own sanctions compliance obligations. I think know your customer is the watchword in all of this, but also I think it goes wider than that. I think it's also about knowing the end client and the purpose of the project, the client's shareholders. Their relationship with the regime, I think, is important as well. The currency of the contract, because as I've said, clearing bank arrangements can bring you into contact with a regime that might not ultimately be obvious. Material shipments, the customer's bank arrangements and the status of payments and shipments. It might be, for example, that an invoice has been levied against someone who then falls under the sanctions list and who you shouldn't be taking payments from. Next slide, please. So that's it from me. And in part two, Catherine's going to talk about contractual considerations.
Thanks, Paul. So moving on now to look at the different kind of contractual considerations, and I guess the key theme and topic and question that we're being asked is, can I walk away from my contract? So I'm going to consider that first, and then move on to the kind of subsequent question of, could I end up in breach of my contract? And then importantly, what can I be doing moving forwards to make sure that I've got some protections in place? So thinking firstly of whether or not you can kind of walk away from your contract, the first kind of provision to touch upon is a force majeure provision. So obviously if your contract has a force majeure provision in it, then you may be able to rely on it, and it may provide you with some relief if you find yourself in contract with a sanctioned entity. What a force majeure provision typically does is excuse a party from performance, and this will be effectively due to events outside the party's control. Typically, the relief that you'll be afforded is that you'll have no liability if you fail to perform your contract, for example, as a result of sanctions. And it's worth just noting here that it's actually only a contractual concept. We'll come on to some doctrines next, and therefore it's really important that you have to have that clause in your contract to allow for the benefit to arise. And as I've mentioned, they will be subject to the usual rules of contractual interpretation and construction. And so it's going to be really important that the kind of clause, if you have got one and are seeking to rely on it, is scrutinised. So just coming on to kind of the scope of these clauses. So it'll be really important to look at and how widely drafted the clause is. Sometimes we see clause referring to, for example, events beyond the reasonable control of the parties. However, some clauses are much narrower in effect and will have an exhaustive list of events. And if that's the case, it's going to be really important to think about whether or not wars and sanctions are included in that list of events. War, we do quite often see referred to in a clause. Sanctions is less likely, from our experience, to be listed expressly as a force majeure event. So certainly where you're relying on sanctions to relieve you, you need to look really carefully at the wording. But it may be, for example, the clause refers to an act of government, in which case it may be that the clause does bite. It's also really important to look at whether or not there is kind of a prevention requirement, or whether or not the contract just has to be hindered. And I think it's really important that the bar will generally be set quite high. And if, for example, it does require prevention of the performance, it won't be enough to simply say that the contract's now inconvenient to perform. And finally, just to look at whether or not the clause can benefit you. It may be that there is a clause in the contract, but actually it only applies to your client, for example. So it's just to consider whether or not you have that entitlement to rely on the clause. So as I've mentioned, the relief kind of provided as a result of a force majeure clause will very much vary from contract to contract. The most typical relief is you're excused from performing your obligations under the contract. However, then it may be that they also do provide an entitlement to suspend and or terminate if, for example, the force majeure event continues for longer than a certain period of time. And one thing I think just it is important to flag here is the effect the force majeure clause may have on the impact of payment obligations. If you are being relieved from your performance under the contract and that it's a mutual release, it might be that, for example, the client can use that to argue that they're relieved from the payment obligations. And I'll kind of come on to how we would recommend we deal with that later on. And finally, with force majeure, and I'll come on to it with the licensing regime, it's important to consider whether or not you have the requirement to mitigate any of the potential impacts. And if you do, obviously it's important you follow it. And I think it's worth just mentioning here the licensing regime that Paul has mentioned. And as Paul has said, the licensing regime may be available to you and allow for the transaction to continue. But it's also really important when considering whether or not the contract is actually impossible or more difficult to perform. If there is a licensing regime available to you and you have obtained a license, then it's less likely in our view that you're going to be able to rely on a force majeure provision. I think finally, just to flag that, of course, any notification requirements, sometimes clauses require you to notify the force majeure event, that they are complied with to make sure you can rely on those clauses. So moving on to frustration, parties may now be thinking of ways out and thinking, is my contract frustrated and therefore can I walk away? And I think it's just worth flagging here that the doctrine of frustration does set a very high bar that has to be achieved before the court will agree that your contract is frustrated. And as we'll come on to, unfortunately, the kind of imposition of sanctions won't automatically frustrate a contract. So I've put on the slide here a few of the kind of criteria. So just as a recap, frustrations where a serious event occurs, and it has to obviously be unexpected and beyond the control of the parties. But then we've got the kind of high bar introduced, so it's got to render the contract impossible to fulfil, and or transform the obligation to perform into a radically different obligation. And there's been various case law on this point. I think more recently, in the case of the Super Servant 2, Lord Justice Bingham said it was not to be invoked lightly and should be kept within its limits. So very difficult to prove it, and a lot of consideration if you're going to try and say that your contract is frustrated. So moving on to see what the court will look at when considering if your contract is frustrated. And one of the key points to mention here, as I've touched upon, is the availability of the licensing regime. And the court will look at this point quite carefully. So in the case of Islamic Republic Iran shipping lines, this was a contract for professional indemnity insurance to cover oil tankers. And what happened was the defendant argued that the contract had been frustrated by the introduction of sanctions which they perceived to prohibit relations with the IRISL. So this went to the court, who held that, yes, the imposition of sanctions did change the scope of services, but actually the nature of the contract had not fundamentally changed. The correct interpretation here was that the HM Treasury had granted a license to the defendant and the claimant to allow effectively the transaction to continue. And this therefore meant that the claimant was still entitled to insurance and the contract was lawful, and it was the license that effectively allowed for the transaction to continue. So whilst it's not directly a construction case, I think it's quite important here to remember that this case shows how the English courts will be slow to accept that a contract is frustrated where there is a license regime available to you. And the court will certainly look at that very widely. So they will consider whether or not you should have and could have obtained a license. And I think certainly in our view, if you could demonstrate that you had tried to obtain a license but it was impossible or it was rejected, you'd be in much better stead than trying to seek frustration where you hadn't tried to obtain a license. Turning now to look at the defence of illegality and whether that will apply. So a contract will be discharged if its performance becomes illegal, and it's a defence to a claim that you have failed to perform your contract. So again, the court will look at a number of different factors, and as we can see here, licensing is coming up again, and whether or not there is the licensing regime, which Paul's touched upon, and whether or not you can get a license. The permanence of illegality will also be considered, and it has been said that a contract can drift in and out of legality. So whilst care needs to be taken when looking at that. Not only do we need to think about obviously English law contracts, it may be that you've got English law contracts but with services being provided in Russia, for example, or it may be that your contract is not governed by English law. Here it will be really important to consider the rules and the sanctions that are applicable where you are performing your services. And generally speaking, a contract won't be enforced if it's prohibited where you're performing the services, even if it's lawful and it's allowed under the applicable law of the contract. I think this also goes to show that the terms of the contract will also really carefully need to be looked at, as was shown by the case of Lamesa and Synergy Bank, which is on the screen here. So this is a fairly recent case where Lamesa Investments was individually and wholly owned by an individual who was subsequently following entering into the facility agreement subject to sanctions in the US. And the question here turned on interpretation of the facility agreement. Synergy tried to argue that they were not required to make interest payments to Lamesa, where this could mean that they would be subject to secondary sanctions. And as Paul has mentioned, there's not a fine for secondary sanctions, but you will be prohibited from trading in that market if you are subject to secondary sanctions. So turning on to the thought of looking at the contract carefully, what the facility agreement said was that Synergy weren't required to make payment where such sums were not paid in order to comply with the mandatory provision of the law. And in short, what the court held was that secondary sanctions, foreign secondary sanctions, could be construed as mandatory laws with which the parties must comply. So in this particular case, Synergy were relieved of making payments, as it would have likely resulted in them being having kind of secondary sanctions imposed upon them. And again, it's just really important to consider that the wider picture and other sanctions rules, as Paul has mentioned. So looking at now whether or not you can terminate or suspend your contract. So what does your contract say in relation to these two topics? Firstly, I'm just going to look briefly at suspension. So obviously, if your contract has a right to suspend in it, then this could be certainly of benefit here. Suspension for convenience would be probably perhaps the biggest benefit, but it may be unlikely that your contract has such a wide right in it. And if not, again, to consider whether or not you've got suspension for non-payment in there. If there are issues with payment, there's asset freezes, the restriction on payment through the banks, then it may well be that you can seek to rely on the non-payment. Also, just as an aside point, even if there is no kind of express right in the contract, all may not be lost if it is, of course, a construction contract for the purposes of the Construction Act. So moving on now to look at the position whereby your contract perhaps doesn't have any suspension rights, and what else a party can do to try and kind of walk away or discuss options with their client. So there are a few kind of commercial options to consider. First of these is if the client has a right to suspend, that you discuss that with your client and see if they are willing to instruct suspension. It may well be in their benefit to do so if they don't want, if they do want the project to resume if time allows. The second is suspension by agreement. We have seen this kind of being utilised on projects, and I think it would be really important here to think about discussing this with your client. Can you agree with your client that you are going to down tools for a while? And I think again the parameters around kind of suspension by agreement will need to be really carefully considered and documented. For example, do you want the agreement to pin the responsibility for obtaining a license on one of the parties? If you do successfully obtain a license, do you want the contract to obviously continue again and come back to life? That might be quite helpful where you don't generally want to fully walk away from a project, but obviously appreciate there are potential issues at the moment. And do you want kind of termination provisions to be considered if, for example, you are unable to obtain a license? So I think that with the kind of suspension by agreement point, it's really important to look at where you want to go with the project, and ultimately, whether or not you want to be able to fully walk away or whether you would be happy to continue on the project if you can. Moving on to termination, again, as with suspension, sanctions themselves are unlikely to be just a pure ground for termination. Again, really carefully need to consider termination for non-payment. If your contract's got that right and there are payment issues, you'll obviously be able to rely on those points. Termination for material breach, if that's in there, you may be able to, but I'd say just a word of warning there that kind of a material breach is a very high threshold. The breach has got to go to the root of the contract, and it's unlikely, for example, to include non-payment. So just to be careful there, and also to consider whether or not your client is perhaps or could become insolvent as a result of restrictions, and if so, do you have a right to terminate for insolvency? Again, if your contract doesn't particularly have favourable or any termination provisions, there is the right to terminate for common law. Again, this is a very high threshold to achieve. The kind of termination's got to be one of repudiation, and the breach has to be so serious that it goes to the root of the contract. So just a word of warning that terminating under common law doesn't come without significant risks, so that not to be kind of taken lightly when thinking about whether or not you can do that. And again, think commercially, if you haven't got rights to terminate, discussing this with the client, they may be prepared to instruct termination if they can. Quite often clients do have rights to terminate, more so than the project team. If the client wants out as well, then they may be prepared to do that. And just a quick note here, see if there are notice provisions, so you've got to give notice of X many days before you can terminate or suspend. It's important that you do comply with those provisions to avoid being in repudiatory breach. So the next question is, well, if I do walk away, can I end up in breach of my contract? And the answer is yes, if there is a risk of repudiatory breach if you do so incorrectly. And where that may arise is the 3 points here on the screen. For example, you seek to rely on a force majeure clause, but actually you didn't have the right to do so, or it wasn't wide enough drafted that you could have relied on it. And again, remember in the background that there is the licensing regime available. And I guess the next options are if you terminate or suspend, and you either do not have the right to do so, or you perhaps fail to serve the correct notices. Again, if you do that, you could be in repudiatory breach, and your counterparty will be able to terminate and claim damages for you. So just, I guess, a bit of a word of warning to make sure that everything is very carefully considered before you do walk away. Of course, it is going to be a balancing act and potentially quite a difficult one. On the one hand, you've got potentially being in breach of sanctions if you carry on providing services to your sanctioned client. But on the other hand, if you do walk away from the contract incorrectly, you'll be in repudiatory breach. So we are kind of advising that there needs to be some form of strategy considered, both commercial, we've talked about a few of the commercial options that you could look into, and legal, to make sure that you're in the best position that you could be in. So moving on to the final question, the kind of forward-looking question is, what provision should I include in my contracts moving forward? So we've talked about force majeure. I think it's definitely important now, perhaps more so than previously, to make sure that you've got a force majeure provision in the contract to afford relief. Ideally, you'd have the widely drafted clauses that refer to any parties beyond your control. But if that's not possible, to make sure that war, which is typically the case, but also sanctions are referred to in the definition. Ensuring that there are rights to terminate due to a force majeure event. And again, just thinking about this point that I mentioned of non-payment, does the obligation, if you're relieved from them, what impact that have on non-payment, and should you specifically deal with that within the drafting? Moving on to termination and suspension, of course, careful consideration of those provisions in the contract, but if they are missing, trying to ensure that you've got those the rights to terminate and or suspend in there. And finally, from me, just looking at the sanctions drafting, perhaps a slightly newer consideration than termination and force majeure, but in our view, there's definitely benefits now of including sanctions drafting in contracts moving forwards. As Paul's mentioned, a lot of insurance policies do have sanctions restrictions or complete exclusions if your insurers could be exposed to breach of sanctions. So not only is it important for the other reasons that we've talked about, but also to ensure that as far as possible, you're not exposing yourself to uninsured losses. And Paul has alluded to it, but we do see the potential for the insurance market to kind of toughen in this area. So it's just to watch for any kind of correspondence there that may be relevant. So what will this drafting look like? Firstly, liability should be considered. So similar to a force majeure, do you want to have a provision saying you're not liable if you would be exposed, or your insurers would be exposed to breaching sanctions regimes? And I think that's quite important for insurance. Do you have a clear right to terminate in there if you need to, if any aspect of the contract becomes unlawful? We think you should consider an element of subjectivity in the drafting. It's, as I say, slightly grey area at the moment. It's all quite new to everyone, and as we've seen from the case law, it's not clear cut whether or not defences will apply. So, for example, the termination of the contract will be permitted if, in the reasonable opinion of the consultant, the performance is prohibited by a sanctions regime. So that gives a little bit of wiggle room, if you like, there. Protection of directors and corporate officers will need to be thought about. They can be fined, as we've mentioned, for breach of sanctions regimes. So ideally the drafting should cover and protect those people. But it really will be kind of the devil in the detail, really. There will need to be careful drafting to make sure that you are kind of adequately covered. So just going to hand back to Paul for a quick summary of everything we've talked about.
So thank you, Catherine. So really, I think the main points to take away are, and as I'm sure many of you are doing anyway, is to just take sanctions seriously because of the potential ramifications for the business, the people in it, and the reputation of the business. Having a global sanctions policy is an excellent idea, and keeping it up to date because it's a very, very dynamic area, putting in place the checks that need to be there. Where necessary, be prepared to apply for licenses, but as Catherine's mentioned, consider the contractual position in the interim, to consider things like suspension arrangements. Make sure when you're applying for licenses that you are making a full and truthful application, because that can generate its own problems. Ensure compliance with the terms of the license, and also just carefully consider the contract to determine whether there's adequate force majeure termination and or suspension drafting to get you where you need to be. A question that sometimes does arise is, well, do I need to worry if the person is subject to an asset freeze, can they sue me anyway? That's a topic in itself, and I think we've already indulged enough of your time, but that's a dangerous assumption, because of course these things are not set in stone, and that person could be delisted at some stage and therefore able to collect damages from you. And also sometimes you'll be dealing with intermediate people who are saying, well, actually, we're not subject to the rules. Maybe we're not under the ownership and control. So it can be a high risk area. As Catherine said, the English courts tend to approach with a degree of skepticism arguments that the contract is now frustrated and at an end. So I think it's important, as with any potential repudiation situation, to be careful with the language considered, take advice before saying anything you may later regret. And also, when considering whether or not your contract has been frustrated, bear in mind the availability of a licensing regime. A court is not going to be impressed if you're saying your contract's been frustrated, when actually in reality you've not bothered to really think about whether or not the licensing regime could apply and assist you in your situation. And as Catherine said, I think we really recommend moving forward that contracts now include robust sanctions clauses, really to just manage the risk and help you get out of difficult situations if you're hit with you're hit with sanctions problems. So those are the main points of our talk, and I really just want to say a big thank you. I appreciate we've gone a little bit over the allocated hour, but as I said, there's a lot there to cover, and I hope this talk has been useful to you. I've got a couple of questions that have come through. I can't spend too much time on this because, as I say, we have gone over our hour. But if anyone wants to contact Catherine or myself wants to email questions that you've got, you may have afterwards, we're very, very happy to do that. Some of the questions that we got through in advance of the talk today, somebody asked, please can you provide some practical examples of the due diligence that small companies should be doing to ensure they do not fall foul of any guidance or legislation? I think, as I mentioned, the main thing would be keeping a check on the parties that you're dealing with, but looking beyond the direct parties, thinking about who is the ultimate client, who's the ultimate beneficiary, why is this project taking place, and also doing some advanced due diligence on the jurisdiction where you're going to carry out the work. Sort of look at what's going on there, look at the political risks. Are there issues about human rights? Is there something that could trigger new sanctions that could become a problem later on? Those sorts of questions are really worth asking. As I mentioned, I think with due diligence, I was asked how far should due diligence checks go. I think as far as pragmatically possible. You really want to be getting up to the top of the ownership tree and working out who who has the ultimate ownership and control? For many of us in the professional services sector, this has become a bit of a bugbear, because we need to do those checks on our own clients. It's not always easy, particularly with certain structures such as private equity, but you are expected to be as diligent as you reasonably can be. And finally, I was asked the question, in the event of a company being found to have been in breach of Russian sanctions, would they be exempt from fines if they could show they'd undertaken sufficient and reasonable due diligence? I think it would certainly be a mitigating factor if you had done the best you reasonably could to work out if any of the people involved in the projects did have a connection to the sanctions list. I think that would be taken into account with OFSI. It wouldn't give you a get out of jail card, but it would, I think, be taken into account in the decision whether or not to set a sort of a nominal fine or a significant one. I think in other areas such as competition law, those sorts of considerations are taken into account. Obviously, you are going to be fined a lot more if the breach was willful than if it was merely negligent, or if you couldn't reasonably have been expected to have known that the person was a sanctioned individual. But I would avoid any assumption that you would get off scot-free. I was asked a question as well about how companies can deal with the situation that can sometimes arise where you might have a jurisdiction such as China or the EU taking a different stance to the US on certain sanctions programs. Now, I mentioned with regard to the EU, they have what's called this blocking statute, which prevents, at least on the face of it, prevents companies complying with certain sanctions programs that they disagree with. It's not all of them, I should stress. So, for example, with Russia, the EU and the US are pretty much on the same page. It's not a copy and paste. They may be designating certain people, but the EU doesn't have a problem with you complying with the US's Russia sanctions rules. But this is a problem that can arise, and you can find yourself caught between the devil and deep blue sea, that complying with certain sanctions obligations can put you in breach of others. There isn't, unfortunately, an easy answer to that. All I can really say is get as much information as possible about the rules of the different jurisdictions, and take a practical risk-based approach, taking into account such considerations as what is the likelihood of actual enforcement of this being detected, and what would be the cost of worst case scenario penalties. For example, if I hardly deal with the US, say, that might practically be of less importance to me than if I'm there all the time, if I've got US persons as directors, if I've got a New York office, etc. So you end up taking a risk-based approach, but I'm afraid there isn't a panacea to sort of guide you through those knotty conflict of laws problems. So really, just to say thank you again to everybody for your attention today. I appreciate we've covered a lot of ground. Most of you remain with us to the end, and really grateful for that. We really value these interactions with you. We'd love to hear about your issues with sanctions, so very happy to continue the conversation after today if that's of interest to anybody. So have a good day, and please stay in touch. Thank you.
Thank you.